Greetings, contractarians. I am Patrick Smith. Welcome back to Disenthrall. Today, we are going to respond to a viewer-submitted question. We are going to do a deep dive into what a contract is from a libertarian perspective, what contracts aren't, the parts of contracts, and we're not just going to do it with me. Oh no, we're going to do it with one of the best minds in this field. He has a plan, she has a plan, and you get to pay for it regardless.
The best way to get someone motivated is to stand for something strongly, deeply, passionately.
Subscribe to Disenthrall. Do as you're told.
My guest today, ladies and gentlemen, is the Stephan Kinsella. Welcome to the show, Stephan.
Thank you very much.
So, Stephan Kinsella is an intellectual property attorney and libertarian writer from Houston, Texas. This is his second appearance on the show here at Disenthrall. It's awesome to have him back. Last time we talked about an intellectual property controversy. He is founder and director of the Center for Study of Innovative Freedom, a member of the editorial board of Reason Papers, a member of the editorial advisory board of the Molinary Review, a member of the advisory board of the Creative Common Law Project. He has published numerous articles, as well as the influential book Against Intellectual Property, and he has a new book coming out this month, maybe even today, called International Investment, Political Risk, and Dispute Resolution, being published by the Oxford University Press. So, man, it's great to have you back. Like, just being able to do a deep dive into a topic I know you have put a lot of thought and have a lot of experience talking about it's an honor. So thanks for returning to the show.
I'm glad to do it. And probably the two main areas I talk about would be intellectual property and rights theory, which, are to most people's minds two of the most boring and eye-glazing topics you could think of. So contracts to me is a little bit sexier. So I like to talk about contracts because it's actually kind of interesting, and most people have some idea of what contracts are, although they're not always correct. And I don't like to say I'm from Houston, by the way, because I just happen to live here.
There you go. All right, that's fair enough. Fair enough.
I don't consider myself to be a Texan, but just a citizen of the world, man. Not even an American.
Yeah, screw collectivism. We don't need those labels.
Yeah.
All right, so a little housekeeping just for the people joining the stream now. Good to see you guys. Lena, hey, my wife is actually in the comments of a stream. This is her second time ever, so say hello to Lena Smith. She's in the comments. Mark Maresca, good to see you. Kurt, good to see you. A little housekeeping here. I'm going to throw this up on the top of the screen. If you'd like to do super chats, because we have people that enjoy submitting questions and doing super chats to do so, I appreciate your support. I want to make sure you're aware, if you do a super chat through YouTube, Google gets 30%. So if you're one of the people that make donations, don't buy Google a steak. I mean, I'm not going to tell you not to if that's what you want to do, but the link at the top of the stream, at the screen, streamlabs.com/disenthrallme, that will allow you to do the exact same thing. It'll get you your question on the screen. It'll allow you to donate to the channel to support us, but it doesn't give Google their bit. So housekeeping out of the way, contracts. I would like to, I guess, start with definitions. We should always lead with definitions. So I'm going to hide us for a second, and we're going to pull up Wikipedia, which is not always a good resource, but it'll at least maybe set a foundation for us to start saying, well, that's wrong, that's wrong, that's wrong. So according to Wikipedia, a contract is a legally binding agreement that recognizes and governs the rights and duties of the parties to the agreement. A contract is legally enforceable because it meets the requirements and approval of the law. An agreement typically involves the exchange of goods, services, money, or promises of any of those. In the event of a breach of contract, the law awards the injured party access to legal remedies, such as damages and cancellation. And it also lays out here in this definition the parts of a contract, but I want to save that for maybe the next discussion. So in terms of the definition of what is a contract, how do you think that is?
I think from a legal perspective, that's not bad. And I'm sure in this show we will discuss the what I think would be the proper libertarian perspective on it and the legal perspective. So those are two different things, because the legal practice diverges somewhat from the way I think that a private law society or a private law order in a libertarian world would treat it. So I think that's not bad. They're taking the Western conventional approach to contracts, which is more the common law approach. The other big system in the world is the civil law, the European system, the Napoleonic system, which is not that different in substance, but some of the terms are different. So you might call a contract in a civil law country like France or even Louisiana here in the U.S., you might call it a conventional obligation. But if you think of the word convention, that just means, well, most people mean a convention is like a habit or a custom. But if you think about it, sometimes it's used in international law as a synonym for the word treaty. Like you can have a convention for the sale of goods or things like that. So a conventional obligation is what is the analog of contracts in the common law, but they're both very similar in how they work. There are some differences. The common law system that you and I are mostly used to, the simplified way to say it is that a contract, which is, as you say, a binding agreement or an enforceable agreement, is formed when there's an offer and then acceptance. Okay. So offer plus acceptance equals binding contract. But the offer has to be definite enough and have certain terms that are accepted by someone accepting the offer, either by their action or by their words. So that's typically what contracts are and how people think of them.
Okay, real quick, because this is epic. Peaceful Easy Feeling just donated $100 to the show in a super chat. He says, best wishes in this tough moment to both peaceful individuals, and congratulations for Anarchast. Peace, love, and good health. Peaceful Easy Feeling. You're always blowing it away with the donations. Thank you for that. I really, really, really appreciate it. And my family is doing great right now. We are quite comfortable. We went on lockdown 2 weeks ago, so before any of this craziness happened, we bought a bunch of food, and so we're quite chill. And how are you doing right now, Stephan?
We're doing fine. We're weathering the storm. No problems.
Good. Okay, so I mean, I wanted to start with Wikipedia. I kind of disagree with it because it seems to the thing that I don't like about it is it has a lot of appeals to government determining what is and isn't a valid one. But it does make reference later to oral contracts. So I think as part of defining what a contract is, wouldn't it just be to say an agreement that you consent to, and the medium of like a paper or written contract is just an attempt to publicize or to codify or to solidify at a moment in time evidence of an agreement, right?
Yeah, and most people don't think of it this way, even most lawyers. If you want, let me start with my view of contracts as a libertarian, and then we can maybe talk about how that borrows from or is held up by the current legal system. And a couple of little matters that sound like pettifogging most of the time, like when you correct someone, but since we're talking a deep dive. So people will say oral or verbal. Now, technically speaking, the word verbal just means using words, right? So verbal does not mean, so verbal would include written contracts. You follow me?
Yes.
So a written contract is verbal because it has words, and most oral contracts are also verbal because they're orally spoken, but they include words. But some contracts are not verbal at all. Like if I don't speak a language and you don't speak a language, and I hand you a piece of an apple and point to your orange, and we just trade, we both understand. So there's communication, but there's not verbal. So contracts can be merely verbal, or they can be merely oral, or they don't even, but they never have to be written except by law for certain things like immovable property or real property, like land. You have to have, those contracts have to be in writing to be valid, and certain things like copyright assignments. But generally speaking, a lot of contracts can be just done as long as you have a representation of the wills of the parties that communicate with each other. A lot of times you'll hear people say, like libertarians will say something like the non-aggression principle, it means that you can't initiate violence, and that includes fraud and contract breach, something like that. So they just throw these things in there. Now, I think the mistake with that formulation is that the non-aggression principle is not really a summary of all of libertarianism. It's just like a stand-in for one aspect of it, like the interpersonal violence part. When you just start cramming things into it, like violence and contract, I think that's a problem. And you'll hear people justify intellectual property, for example, based upon contract. Or you'll even hear Bitcoin enthusiasts talk about how there's going to be smart contracts. And you'll notice they almost never define what they mean by contract. It's just a smart contract, something that automatically happens, but it's not clear why that's a contract. So to my mind, as a libertarian, you think about this fundamentally. And by the way, I believe that Murray Rothbard and a guy named Bill Evers, Williamson Evers, in the 1970s came up with a kind of a radically new approach to contract law that was different than the way the legal profession and the government courts and scholars have looked at it. And I think it's revolutionary and it's underappreciated. And my own view is built upon theirs and slightly extends it a little bit because I'm a lawyer and they were like historians and economists, and they only knew so much about the legal nuances. But what they did was just, I think, incredible. And I think this is the solid right way to look at contracts. So from a libertarian point of view, we live in a world of scarce resources, and we have the possibility of conflict. When we want to perform actions, we need to employ these scarce resources when we act. And by their nature, only I or you can use these things at a time. And therefore, if another person wants to use this resource that I'm using, including my body, then there could be conflict. So there's a potential for conflict, physical, violent, grappling conflict. That's the whole purpose of property rights, is to assign ownership rights to these resources so that we can use them peacefully and in prosperity and cooperatively together, and avoid trampling on each other's rights and be secure in our own rights. This is the kind of the background of the entire libertarian ethic. And the libertarians believe that you should very consistently respect property rights assigned according to some simple rules. One of them is, if there's a resource that two or more people dispute, we have to decide who owns that resource. Okay. So the first thing we ask is, who, between these two people, who owned it first? Who started using it first? Okay. So earlier use beats later use, because later use is what a thief is. A thief is someone who comes along later and takes your stuff from you. So the earlier guy has a better claim to it. But another way would be contractual title transfer. This is the way Rothbard and Evers would look at it. So if between you and me, you owned it first, but then you gave it to me by contract, and that would include gift. It would include a gift or a sale, anything that's consensual. As long as I transfer the title to you, I gave my ownership to you. Now you have a better claim than me. And because I had a better claim than anyone else in the world, I have a better claim than anyone else in the world. This is how it works. These are basically the roots of all libertarian law. So if you think about it like this, contract is really just the outcome of the fact that owners of scarce resources are the ones that have the right to decide what to do with them, right? So if I own my body, that means that there can't be slavery, because it means that a slave owner can't tell me what to do, because I'm the one who gets to decide whether he can whip me or shoot me or kidnap me or whatever. I'm the one who gets to decide that, not him, right? But what that means is that if I own a resource, whether it's a car or a piece of land or my body, as the owner, as the property owner, as you see, this is why property is key and contracts flow from this. Property is not based upon contract, but contract is based upon property. In this way, if I own a resource, I do have the right to prevent other people from using it. That's the right of exclusion. But I also have the right to permit them to use it. That's why there's a difference between rape and consensual sex. That's why there's a difference between me using an Avis rental car and me stealing someone's car, right? I'm using the Avis's car with their permission. Or if I go to a hotel room, I'm not a squatter or a trespasser. I am actually renting the room from them. I have a lease or a temporary use right. Or if I invite a dinner guest to my house, they're not a burglar. They're they're an invitee, right? They have what's called a license. That's where the word license arises. And so by virtue of having an ownership right in a resource, by having a property right in a resource, the owner has the ability and the power to deny permission or to grant permission. Now, the granting of permission can be complete and final and immediate, or it can be temporary and conditioned and partial, right? So I might loan you my coffee maker for a day, or I might loan you my car for a day, or I might give you my car as a gift, or I might give it to you in a year from now with a contract, or I might sell it to you in a year with a contract. So there are different things you can do as the owner. You can express your will to relinquish partially, completely, temporarily, permanently, immediately, or conditioned in some of it in the future. And this is what contracts are. So contracts are just the expressed will of an owner of a resource about when and how someone else gets to use it. So that's what contracts are. Contracts are basically the divesting of your ownership of your resource. And the reason, in my view, that you have the right to do that is because you have the right to abandon property. You have the right to abandon it because you acquired it. And if you can acquire something either by homesteading it or by contract from some previous owner, then you can undo that and just stop intending to own it, or even die, or whatever it takes. But the point is, you can stop owning a resource at a certain point in time. That's abandonment, which is a type of contract in a sense, except you're kind of giving it back to the world and you're making this property unowned again and someone else can homestead it. But instead of doing that, you're abandoning it, so to speak, in favor of a given person, which is what a contractual title transfer would be. So this is how I look at contracts. And the difference between this view and the conventional view is that the conventional view, as you read and as the civil law states, is that it views contracts as giving rise to binding promises or enforceable obligations or agreements or promises. And then what the government, so what the state courts say is this. Okay, so I have a promise with you, which if it meets a certain formal criteria, offer and acceptance and consent and consideration is another one the common law requires, that you have to give something in exchange, because they think it has to be an exchange of something, even if it's not of equal value. Like they sort of recognize the kind of Austrian point that you can't have equal values. Okay, you'll see something if you look it up. You have to have consideration for a contract, even if it's a mere peppercorn. They say that, a mere peppercorn, which means that you can give me $10,000 car and I can pay for it with a mere peppercorn, like a penny. And this is why you'll see in a lot of contracts, it'll say, in exchange, I give you $1 or $10. Even if you don't actually hand it over, they're trying to fulfill the formality requirements that the common law added on to this idea that a contract has to be an exchange, which of course is not true in libertarian theory and even in the legal theory, because you could have a unilateral or a donative, you could have a donation or a gift, which is not, there's no consideration for a gift. So from our point of view, it's all unified. The owner has the right to get rid of this property either by abandoning it to the world, by destroying it. If you want to destroy it, that's called abuse in the law, abuse. That's why the word usufruct is used in the civil law. Usus, fructus, and abusus. Property has three parts: usus, fructus, and abusus. Usus is the right to use it. Fructus is the right to the fruits, the civil fruits, which would be interest on money, or the actual fruits, which would be fruits from a tree, or like a cow giving birth to a calf, which is the fruits. You own the cow, you own the calf. You own the apple tree, you own the apples. You own the money, you own the interest. You own the fruits. Usus, fructus, and abusus would be the right to destroy.
So before we get too far ahead, I want to call out to a couple things that you said. So long-term viewers of this channel would be very familiar with two things that you just kind of heard him allude to, and that's because Kinsella is the person that taught me these things. When I say what are property rights, and I say that owning something is the right to exclude others from the use of it, I got that from this guy right here, and that is the best definition of ownership I've ever found. So kudos to you on that. And the second thing that I talk about frequently on this channel is, and I don't even know what to call it. It seems weird to say like the Kinsellian view of property, but like, Robert Locke's 3 rules of homesteading, get there first, separate it from nature. It's like make first use of it, separate it from nature, and what was the third? Mix your labor with it, right? Kinsella has spoken at length and very astutely on this topic, and he's sort of boiled it down to just that first use. He's kind of eliminated what I guess the chaff in maybe the Lockean property rules, whereas like the mix your labor with it sort of implies that labor has some kind of inherent value, and like there's this like a ephemeral, mixing your labor as if it was actual property in with real property to sort of link it to you. And so Kinsella has, and correct me if I've got you wrong on any of this, but you've been very clarifying on what homesteading is, how it's done, and things like that. Go ahead.
Yeah, it's John Locke, not Robert, but little typo there. Yeah. It's okay. I've tried to, and I think I have added some clarity to it, and only because of Rothbard's, well, I would say it's a combination of a couple things. Rothbard's radical libertarian perspective plus his views on contract theory. And then Hoppe and his reliance upon Mises and the emphasis on scarcity as a part of property rights, right? Because of Austrian economics and Mises. And because I was trying to sort out this puzzle of intellectual property, it required, after years, like, this is the right way to see what the real error is in intellectual property. And I hate to always harp on that topic, but it keeps. So John Locke, who was heroic in a way, John Locke was trying to come up with an argument that there's some private domain protected from, the government's interference, right? So he was trying to argue against this guy named Robert Filmer and his argument that God gave the earth to Adam and Adam owned it. And so all the kings nowadays basically inherited their title from Adam. So they basically are emissaries of God, owning all people as their serfs, right? That's where serfdom came from, right? Feudalism. And Locke was like, well, really, God gave it to Adam, but he gave the rest of the earth to humans in common. And therefore, people have the right to own their bodies and themselves, and they can go out and homestead things. So when they mix their labor with it, they own their labor because they own themselves because God gave it to them. And so he was coming up with a somewhat convoluted argument to argue for individual rights against the state. So I don't want to be critical, but this was, 300 years ago. And
yeah, it's okay to refine ideas. Yeah, I mean, that's what we need to be doing.
He was more flowery. Yeah, he was flowery. He was metaphorical. And it's even like David Hume later pointed out, this whole step that you own yourself and therefore you own your labor and therefore you own the things you mix it with is sort of like an unnecessary step or two in the argument. It is true that when you, as Hoppe calls it, when you emborder property, that is when you start using an unowned resource and you put up a border around it that sends a visible signal to the public that, hey, I'm putting up boundaries around this and I own it now. You have to use labor, but in other words, you have to act. But it just means you act. You don't have to make the assumption you own your actions to do this. It's just that it's necessary to do something to separate this from the state of nature and to put up a public social signal that, okay, now I'm the owner of this. You can avoid this property boundary if you want to live in peace with me, and you go find your own stuff, or you can buy it from me by contract, something like that. So yeah, I think and all this stuff helps clarify so many issues, like the intellectual property issue. You'll hear people say like, well, you should own your inventions and your novels and your musical works because you created them. So they're going back to this labor aspect of Locke's argument, where people think of you own yourself, you own your labor, and you own anything you mix your labor with, and therefore you own anything your labor helps create of value. This is sort of the Ayn Rand line. Mm-hmm. So they get this whole idea in their head that you own things that you create. So they start thinking that property rights come from creation, but they don't. They never come from creation. They only come from finding an unknown thing and starting to use it, or basically buying it from a previous owner. Contract. That's the only ways to gain property. Well, there is a third, and that's restitution. Like if someone commits a wrong against you, and so then you get some of their property, they have to pay you back. But you can think of that like a type of contractual transfer. So that's it. I mean, but you never created anything ab initio. All you do is rearrange things and make them more valuable, and you might get more wealth because of that. But it doesn't mean that you have created new property rights.
We did a video on this channel that I think I'll send you after this, called, it's kind of cartoony, but the monologue behind it is really good. It's called Why is Property? And I'll probably send it to you after this. For those watching along, search our channel for it. It goes through why property exists as kind of like a predecessor discussion to what is property and then the ways property is transferred. Okay, so we have this thing called a contract, which I love what you said. It was like it was a confluence of wills. It was like a meeting of wills, and a contract is sort of like an expression or a freezing in time of that moment of connecting wills.
I forgot what my formulation is, but the classical one, law is a meeting of the minds. A meeting of the minds is what the laws, which is one reason, by the way, which I have a problem with this not smart contract. What's the idea of the Bitcoin smart contracts, right? Yeah. And also the fine print that we see on, we used to call it shrink wrap in the old days when people physically bought software, right? But not just shrink wrap, but now we call it click wrap, right? The fine print and all these things that everyone just scrolls through and hits the checkbox. I mean, what if at the bottom of one of these forms, it said, and by the way, you agree to pay me half of your income for the rest of your life.
Well, you clicked agree.
Right. And if you have this sort of mechanistic or legalistic, simplistic view of contracts as being, it's almost like Protestantism and legal positivism, like this idea that law comes from a sovereign and it's got to be written down. I mean, like these income tax protester nuts who say that it's not illegal to not pay your income taxes because it's not in the law books. They'll use this term, the law books. And if they ever cite Black's Law Dictionary, you can tell they're probably a conspiracy nut, right? Because that's all they know about law is what they can look up in Black's Law Dictionary, right? But the point is, they think of law as what's written down in a statute by the government, by the parliament, or by the Congress, right? And so they think of law this way too. But law contracts don't have to be written, as I said. It's just an expression of the wills of the parties. It's basically an expression of the will of the transferring party. Another clarification that I think can be and has to be made is most people think, okay, you'll hear this argument. You'll hear Kinsella, you say that you can't own your labor or you can't own your ideas, yet you can sell them. How can you sell them? And sale is a type of contract, right? So how can you sell them if you don't own them? If you can sell it, it means you own it, right? So you hear this argument all the time, usually in defense of intellectual property or in some other theory, right? The mistake here, I believe, is that people are conflating economic with legal and normative concepts, okay? So in economics, we try to understand and explain human action, why people do things, right? So we think of our fellow human beings as human actors with purposes, just like we have purposes, which means that every action we take is some employment of some means, some scarce resource, some scarce means to achieve certain ends, certain end goals, right? This is how we characterize crimes like first-degree murder versus manslaughter or negligent homicide. And this is how we understand our fellow humans, what they're doing. We think that they are doing something that's in the praxeology, the human action framework. They are using means to achieve some ends, some personal goals they have. They might be evil goals, they might be good goals. The means might be evil means, it might be good means. You know, I might use my knife to stab a bad guy That's probably a good use of a means to achieve a good end. I might use a stolen knife to kill an innocent person. That's too. I mean, there's a mixture of these things, but we understand other people's actions in terms of means and ends. And this is what economics. The goal of economics is to understand what people do in the market context, which means is called catalactics, which is a subset of economics aimed at understanding things people do aimed at monetary gain, right? In a monetary economy, right? Because not everything we do is monetary, but everything we do is economic. But so in the economist point of view, we see people engage in social intercourse, social interaction, social exchange, social cooperation, and which means sometimes people engage in cooperative action, including exchange, which means someone has possession or use of a resource and they give it to the other one for some reason, his own personal reason. It might be a gift. It might be for gratitude. It might be out of a sense of obligation. It might be to induce the other person to give me the other thing. So if someone exchanges an apple for someone else's orange, that's an exchange. Okay. And economists call that an exchange. Legally speaking, over time, the property rights system would start protecting these things because that's what contracts do. So you have a legal exchange, which the economists see as an economic exchange. You follow me? So you have the same sort of concept and term, and parallel activities happen. But sometimes I might give you my property, my resource, not to get title to another resource, like an exchange of two owned objects, like an apple for a banana or whatever. But I might do it to induce you to do a service for me, right? So basically, that's payment for a service. Now, economically, you would still call that an exchange because you're just trying to explain why did this person give the apple up? Why did the other person paint the guy's fence? Okay, the reason was each one wanted what the other one had, right? Or to induce the other one to do something. So economically, the problem is legally, then we start saying, well, legally, it's a sale of a service. Okay. So then now I think that's the mistake. That's the mistake the law made. It's not really the sale of a service because you don't own your service. It's really economically, you can call it a sale of a service, but that's more metaphorical. But legally speaking, it's just a one-way sale of the apple or whatever is being paid to the service provider. The service provider is not selling you labor. He's just performing something you want him to do, and you're inducing him to do it by your conditional. That's why I said earlier, contracts can be immediate, absolute, unconditional, or they can be future-oriented and conditional. And that's usually what they are. So usually I'll say, I will pay you $1,000 a week as your salary if you show up every day and you stock these shelves at Amazon for me or whatever, right? So it's a condition. The condition is if you show up, you get this money, right? Now, economically, if you want to say that the Amazon worker is selling his labor, you can say that. But legally speaking, and from a libertarian point of view, he's not really selling his labor. He's just performing the action that will trigger the conditional transfer of money to him. And it works out. It works out for everyone. And then you can have more and more and more and more complicated contracts, of course, with security obligations, things like this.
Yeah, I tell people all the time, labor is not a valid form of property, so it's not something that you can sell. It's we're going to make an agreement between us to have a future transfer of property that you own contingent upon me using my property,
yes.
And in some cases, my body property. I agree to use my property in a way that you want me to in exchange for a contingent future agreed upon transfer of your property. That's what a labor contract would be, right?
Yes, and the important thing about this and the way you just put it is it's a future transfer of title to a resource, which means it's a transfer of title to a future resource. Okay. Now, the thing about future things is they don't exist.
Yes, we're getting into it. This is one of the things you taught me that blew my mind. So I want everybody to listen up. This is really important about contracts. Please go ahead.
So the future is uncertain because it doesn't exist yet. And so therefore, if I give you this pen right now, that's one thing because the pen exists. And then if you own it and I don't let you take it from me, I'm stealing your pen. But if I give you my future pen in a year, okay, that contract that contractual title transfer is necessarily conditional. It's conditioned at least upon one thing. That is, well, the future existing in a year and me having a pen in a year.
You having the pen in a year. Exactly. Yeah.
Right. If there is no pen, then my failure to give you the pen is not an act of theft because there's nothing that I'm stealing from you, which is the problem, in my view, with Rothbard and Walter Block's argument for debtor's prison, for example. It's like, so the idea that if you don't pay a debt, like if you take a loan out from a bank and you owe it in a year, say I borrow $1,000 now and I owe $1,100, which is say $100,000 with 10% interest in 1 year. And in 1 year, I don't repay the $1,100 to the lender, to the creditor, to the bank. Then I'm stealing from him, and I could, in theory, be subjected to debtor's prison. Now, Rothbard didn't like the implications of that argument, so he tried to avoid it by saying, but that would be disproportional punishment. So theoretically, it's theft, but you can't put a guy in jail because that's disproportionate punishment. So he tried to avoid the uncomfortable implications of his own mistaken application of his own contract view, if I could put it that way. Like Rothbard was a giant, but he only went so far, and then and so I asked Walter Block this. I have a whole podcast where we debated here in this room. He was on my couch and he was sleeping over one night. And I said, let's have a podcast. Let's discuss this. And I never could make progress with Walter, but because I said, Walter, if there's no if there's no future money to steal, what's being stolen? And Walter thought about it. He says, okay, it's the previous money. I said, you mean I retroactively stole it when you loaned me the money? The 1,000, not the 1,100. When you loan me the 1,000, I was stealing it then because in a year from now I was unable to pay back a similar amount plus interest. I said, but if I was stealing it then, but you consented to me using it and taking it to spend on my project, because that's why I borrowed the money, right? I want to spend the money. That's why but I can't spend the money unless I own it 100%. So how could it be conditional then? So the whole thing falls apart. But the reason I bring this up is the conventional view of contract is that contracts are enforceable agreements, as you read from Wikipedia, or in the civil law, they are agreements that give rise to obligations, conventional obligations. So in both cases, when they say enforceable, what they mean is, or an obligation, that you have, if you don't comply with the agreed upon terms of the contract, you're in breach of contract. And when you're in breach of contract, there should be remedies, which is another thing that you read from the Wikipedia page. But now, theoretically speaking, like if you think about the Rothbard Block idea about voluntary slavery contracts or about a debtor's prison, theoretically, the remedy is that you're a thief, right? You're basically a thief, because you didn't hand over the property that they own, even though it doesn't exist. And so theoretically, you're in breach of someone's rights. It's like you assaulted them, right? Or theoretically, let's suppose I have a contract to sing at your daughter's birthday party, and I back out of the contract. And now the other guy sues me and says, you breached the contract, so you had an obligation to sing, you didn't sing. Theoretically, the court should order the deputies to put a gun to your head and say, go sing at the wedding, go sing at the birthday party, right? They should coerce you to comply. But the courts say that that's impractical. In almost every contract, even a title transfer, except for real property, for land, we're going to make you transfer the land. You have to transfer it because we don't need your assistance to do that. We can just put on the real property records of the county. Okay, the court's going to say that the property did transfer because you agreed to do it earlier. But other than that, the courts don't enforce what they call specific performance. Mm-hmm. So all they do instead is they award a sum of monetary damages, because the courts don't want to have the burden of making sure that you went to the party and sang the right way and you weren't surly about it. No one wants that. So even though they say that contracts are binding obligations, they never enforce them with what's called specific performance. they only give you an award of monetary damages, which means that all contracts really amount to, even in the legal system, is really a transfer of title to owned resources.
Mm-hmm.
It's never actually a sale of labor. It's never actually anything like that. Now, the only exception would be like if you sign up for the military and our volunteer army right now, which is not really that voluntary because half the people that sign up probably do it because they're impoverished because the government, makes these people ignorant because of public schooling, and then it increases poverty and increases unemployment by the business cycle and by regulation and taxes. So I think we have a form of economic conscription even right now in the U.S. I mean, but the point is, you sign up to the military and it's so-called voluntary. That's the one job you can't quit, right? You can quit your job at Walmart. I could fire an employee at Walmart. It's kind of a voluntary mutual relationship. But if you join the military, you can't quit before your time is up, or you'll be court-martialed or put in prison. So, but again, that's an exception to the general private law rule, which courts don't. So my point is the courts, the way they act is very in accordance with the Rothbard-Evers theory of contract already, which is basically, it really always amounts to a transfer of title to scarce resources. Which,
let me try and say it on. Go ahead.
Yeah, go ahead. Let me just write a note down. I'll bring this up in a second. One more thing I want to mention in a second.
Okay, I wanted to just try and say it all in my own words and see if you agree with it. So the way I've described contracts before are a promise to, generally, like a labor contract would be, to use your resources in a way that the other person wants you to, in exchange for the change of ownership in some form of property, be it an asset or money or something like that, at a future date. And you generally upon completion of whatever labor it is. And if the asset that was promised to be exchanged doesn't exist at the future date, and it wasn't in the contract how you were going to agree to handle that eventuality, then it's sort of like, okay, well, the agreement just sort of fizzled out, or it's just kind of nulled out. Yes, you may have used your property in the way you agreed, but the property that they agreed to transfer to you, they didn't own anymore at that point in time. So without any kind of a priori or some sort of like agreed on community standards of contract resolution, without any of that being agreed to beforehand, then you don't have any kind of restitution, or what's the word? There's no penalty for
recourse. No recourse.
Recourse. Thank you for violating that kind of contract, which is the thing that I see people not think about all the time. If you want to have recourse for a contract breach, then you got to put it in the contract. It's, at least from a libertarian contract perspective, penalties. So if you agree to pay somebody for a service, they complete the service, and you have the property at the time of the agreed upon ownership transfer and don't give it to them, the property is already automatically owned by that person. You're just in sort of invalid theft possession of it. By holding it onto someone else's property against their consent, you're a thief, right?
Well, I don't think it wouldn't be, I think the word would be conversion, right? But I don't think it would be theft or conversion or trespass unless you refuse to turn it over, because it's understood that if the contract is set up where the previous owner is going to be in possession of it until the new owner gets it, that's like a licensed temporary custodial relationship or something. But no, I actually don't agree with. I don't think I agree with what you just said about having no consequences. Okay. And I would also be a little bit careful about the word promise, and only because the conventional view of contracts is that it's binding promises. In a sense, just like we libertarians distinguish morality from legality, like everything you have the right to do isn't always moral, and everything that's immoral to do shouldn't always be illegal, right? In a way, promises have nothing to do with contracts, and vice versa. However, the stickler sort of detail and the obsession over that word, like I think it led Rothbard a little bit astray. This is why so Rothbard would say that a promise is not the basis of contract, which I agree with. A promise is just you telling someone what you intend to do. Like, I promise I'm going to be faithful to you. I promise I'm going to be a good daddy to you, whatever. I promise I'm going to quit watching porn, whatever, it's a promise. It really has nothing to do with transfers of title or even a legal binding obligation. But people, usually when you make an actual contract, sometimes people use the word promise to explain their intentions. And I see no problem with that. Like if I say, I promise to give you $1,000 in a year. Okay. It's not a binding obligation, or it's not a valid contract because promises are enforceable. It's a valid contract because the word promise was meant to convey the abandonment of title to that resource in a year. You follow me? And just as I said earlier, contracts don't have to be verbal or written or even verbal or even oral. Contracts still require a level of communication. So they require a type of something you can call language, right? It has to be some kind of two intelligent beings understanding each other. That's why meeting of the minds comes about, right? And so language is always to some degree imprecise, and it's also always necessarily informed by custom and default conditions, okay? So in the law, this is called suppletive, suppletive, suppletive terms or gap filler terms. So the idea is that when you say something, when you communicate your understanding, I'm getting to the point of implicit conditions of contracts. So I think in the loan contract we talked about, I don't think that the creditor would be out of luck on the day of the due date if the debtor is penniless, because I think that if they had bothered to sit down and discuss that at the day of the loan, they would have both agreed that, and if you can't pay me $1,100 on the due date, then you have to pay me $1,100 plus interest going forward as soon as you come into possession of it, right? And if people don't specify every single detail in their contract, and by the way, they never can because the world is uncertain, and even if you have a 1,000-page contract, you always might leave something out. And in those cases, all you can do is turn to a tribunal that can settle this thing, and then they will always turn to custom, community understanding, reasonable interpretations, etc. And in the end, what they will say is they will make a decision, right? The court that both parties in a gray area. Remember, it's a gray area that they caused. They caused it because they failed to put clause 17.17 in the contract specifying this thing. So they caused this gray area to arise, and they forced some third party to have to decide this thing in a sea of kind of uncertainty. And all you can do is do your best to do justice. But the point is, whichever way the court decides, number one, neither side can really complain that much because they had the chance to hash it out in detail ahead of time, and they didn't think it was worth it, right? To hire the lawyers, to go into umpteen detail. They took the chance that there might be a little gray area, and when that happens, we're going to have to settle this, and one of us might lose. Mm-hmm. And number two, from that moment forward, the community learns, you see what happened here? And if the court decides the wrong way, according to the common view, people will start putting that in their contracts. Like, for example, I think we're about to see this right now with this coronavirus thing. You have tons of hotels, cruise ships, airlines, venue cancellations. And I guarantee in some of those cases, the people that put their deposit down won't get their deposit back, but they want it back. And in the other half of the cases, the hotel is going to insist that they pay the remainder that they owed. And they're going to have a dispute about whether or not a coronavirus was an act of God or force majeure that should break the contract, or whether it's not. And there's going to be, and insurance companies are going to be hit with all kinds of claims right now, right? And they're going to try to get out of it. And so I guarantee that right now, the lawyers for insurance companies and hotels, and they're already revising contracts going forward with some kind of coronavirus clause. Now, which way they're going to go, I don't know, but these things are going to start being specified, and they're going to be specified because there's going to be squabbles and disputes over the aftermath of this. But yeah, so I think that there's nothing wrong with implicit or even tacit obligations or tacit contracts or implicit, and the reason is because language is always based upon custom and context, and that is always going to play a role. So, if you and I make a deal,
I kind of hard disagree with you on this implicit thing. So this might be a really good discussion. I think that's social contract. Like that's just that's enforcing rules that people didn't consent to, and that's unlibertarian it on its face, right? But let me get you to respond to that, and as well as I don't think we ever got your definition of a contract. Let me give you mine really quick in one sentence. It's a communication of consent to the use of or transfer of property. That would be like my one sentence version of what a contract is.
I like that. I like that. I think that's good. I like that.
Because it is a communication. Without communication, you have nothing. It's all about consent because that's what this is like the essence of a contract. It's a communication, it's a consent, and it's either for the use of or transfer of ownership. The use of property or transfer of the. Go ahead.
Or you could say it's a consensual temporary or permanent, complete or partial transfer of use rights over a resource owned by that person. So, but it's the same idea. I think that's basically what a contract is. Yes.
Temp or permanent. What was the second part? I want to write this down because this is good stuff.
Well, I was going to say temporary or permanent. So it could be like a lease or a loan, or it could be a total sale. It could be complete or partial. So you and I could have a co-ownership arrangement over like a house or something. Or maybe you have the right to live in it and I have the right to have it when you die, something like that.
Or, covenants for HOAs and things like that. Yeah.
Yep. Homeowners and restrictive covenants and things like that. And by the way, I think this view of contract also can explain the entire restrictive covenant issue, and also things like trusts and even corporations, how you can set up a corporation that can last forever. Once you have this kind of solid Austrian libertarian property rooted based view of contracts, then I think all these other issues, which sort of nags. And by the way, I've heard your argument before about implicit. I know it bugs a lot of libertarians because they think that you're opening the door to the social contract. And one reason I think that you think that is because you said you're agreeing to rules, but you notice that under our theory of contract, it's not about a binding promise, right? It's not a binding promise. It's just a specification of who owns a resource. And we always have to have that. That's the whole purpose of property. We always have that issue of what rules do we have that determine who owns a resource. So that's why you can think of contract as a subset of property rights, because again, property is who owns a resource that's in dispute. We ask who had it first, and was there a contract? Who used it first, was it transferred after? Right. That's literally all the contract is. That's all there is. Determining who has the highest claim on a piece of property. Right. Okay. Right. Better. And I've actually thought like you could summarize all of libertarianism with the two words better title, which is sort of a legal term, better title. Who has better title? This is another thing. Some libertarians, they fight this Rothbardian, Lockean, proprietarian perspective because they'll say things like, well, you could never know who owns property absolutely because there was wars 500 years ago and someone stole this land from someone else. It's like property is not about proving absolute title to something back to the days of Adam. It's only about better title. It's only about relative title. It's only about knowing who has a better claim to the resource with respect to anyone who could possibly other dispute it, or even the rest of the world, which is all other living human beings, right? And if you and I are disputing this resource, and this is what in the law, the way the law does it, I think it's the right procedure. You don't trace it back to Adam. You trace it back to what we call a common ancestor in title. So like if two guys they both claim this piece of property, and we both trace our title back through some transfers back to one guy named Joseph, 175 years ago in Pennsylvania. Now, we know that from our point of view, Joseph owned it. It doesn't matter if Joseph stole it from someone else because we're the only two fighting over it. Then you'd follow what Joseph did with it after that. And if there's a split, then one of those transfers is invalid. Like he did it. He gave it to C after he gave it to B. So C's title was invalid. And so that chain is invalid. So that's how the law works. And that's the only practical way it ever could work. But the point is, and Rothbard talks about this too in a sort of Rothbardian libertarian way, about how, like, just because we say that this property is not free of original sin, let's say, right? It's like somewhere in the chain of title 700 years ago it was stolen from some guy. That doesn't mean that your current title is invalid, because anyone who wants to take it from you has to say they have a better title than you.
Right.
Right. And if it was tainted 700 years ago, that doesn't help them either. Anyway.
Yeah, they would have to have some kind of higher claim than the owner that had it stolen from them to win in that.
Now, the term you were looking for earlier is called liquidated damages. Like if you want to have a so-called penalties clause. Yeah. And I think most people would tend to do that.
And an arbitration clause, right? Like an agreement to who is going to arbitrate. Like an agreement in the contract should be what framework of rules or context or subjective societal norms will be standing in judition or in dispute resolution over this contract should there be a problem, right?
Well, but let's say that I live in a community that's a pretty advanced libertarian society, and everyone pretty much respects property rights, and there's a nice justice system that's private. And I buy your cow for $100. We might not want to. We might just want to shake over it because we know that in other similar disputes, people always use arbitration, and they tend to have these default rules that they apply. The default rules or the suppletive rules or the gap fillers that I mentioned earlier, which you could call the implicit conditions, but it's not really implicit. It's just we're assuming that that's what the legal system would do, right? So we might not bother to write up a contract because we know that we're just writing up something that's going to be the case anyway. Just like lots of people now get married and they don't bother to have a prenuptial agreement because the prenuptial agreement they would write would tend to be roughly the same as the state's default divorce and marriage laws already, right? People that don't want that, they write up a prenuptial, right? So if you're confident that the customary and the default rules that will be applied are what you want anyway, you might not go through the hassle of writing it all down because it's just a waste, right? Only if you want to vary things. I think like in Louisiana, there's something called a covenant marriage that was enacted about 15 or so years ago, which allows you to choose like marriage plus when you get married. And if you choose that, it makes it extremely difficult to get divorced. Like, you can't just have a no-fault divorce. You have to go through some kind of criteria. But some people opt into that. Not many, but you can, right? So defaults, I think, are necessary in the law. The other thing I was going to mention a little while back is this view of contract does imply something I think is significant for the law, which is that there's no such thing as a breach of contract. It's impossible to breach contract. So right now, because we think of contracts as binding promises or binding obligations, if you don't comply with your promised obligation or your promised activity, then you're in so-called breach. And then you owe damages to the other party, some remedy, usually a payment of money, which, as I said, could have just been stated as, if I do this, then I pay you this much money. But that's not a breach of anything. It's just a conditional transfer of title to property, right? Now, what's interesting is in the Chicago kind of, the free market literature on contracts, they have this idea of, it's called efficient breach of contract, which means that we shouldn't have penalties for breaching contract. You should only have to pay the damages that you cause the other person, so that if you need to economically breach a contract, you should be free to do so because it might be better for the economy. So there's sort of a roundabout free market way of getting at what I think would be the Rothbardian way, which would be there's no such thing as breach of contract at all. It's just contracts are not obligations, so there's nothing to breach. It's just a set of conditional title transfers. And if you don't perform the action that the other party hoped you would, it triggers a set of payments of damages. Like if you show up and sing at my kid's birthday party, then I transfer $1,000 payment to you. If you fail to show up, you have to pay me $500 in damages. That would be a liquidated damages clause. But it wouldn't even really be damages. It would just be a transfer of title to $500 just to incentivize them. Although the reality is you don't really need to incentivize service workers to perform their obligations because they have a reputation issue to worry about, right? If they get known in the community as someone who doesn't show up and do what they promised they would do, they're not going to get business anyway. So a lot of this is academic in a sense.
Before we, I want to make sure, did we actually hear your definition of a contract? Because I want to make sure we did.
Well, I liked yours, and then I said you could slightly formulate it, alter it by saying that, a contract would be a consensual
communication of consent to property use or the temporary or permanent, complete or partial transfer of ownership is what I wrote down.
I would. The thing is, I wouldn't call the contract a communication. The contract is communicated, but the contract would be a consensual transfer of title. That's what it is. So a contract would be a consensual, communicated transfer of title to an owned resource, and where that transfer could be temporary or permanent, partial or complete.
Nice. All right. Cool. I like it. So we have a lot of.
By the way,
go ahead.
Let me mention one other thing. The one other major theorist on this issue is Randy Barnett, who's a well-known libertarian law professor, and he's written a lot of stuff. He calls it a consent theory of contract, and it's really good. And it's really heavy, really deep, very legalistic. It's not quite along the same lines of the Rothbard approach. It's more trying to reform the legal view of contracts as obligations. But there's a lot of good stuff in his stuff there. It's called Randy Barnett's A Consent. Yeah, that's him. A Consent Theory of Contract. And he's brilliant. But I think the best approach is this Rothbard Evers proprietarian approach.
So we've got quite a few questions in the comments. If you were waiting to say something, I remember you saying you wrote something down you wanted to bring up. Go ahead while I kind of sift through the comments and queue up some questions. If not, I can just go ahead and start.
That was the thing on breach. I already said it.
Okay, got it. Matthew Sands asks, why does labor need to be property for you to sell it? You can sell your labor because you own it. It doesn't need to be property to be yours. You own your actions too. They're not property. My first thought on that is there's some contradictions in language there. It doesn't need to be property to be yours is sort of self-contradictory. If something is yours, it is your property. So necessarily it has to be yours. It has to be property. What do you have to say on that, Stephan?
Yeah, there's I've got it. I can send it to you later. I forgot the name of it. It's one of the Austrian or classical liberal guys like Mencken or someone like that. He said something like, so this use of possessive, so language is ambiguous and it can lead to equivocation, right? So when we, like the word yours has different meanings, right? I mean, this is my country. That's my wife, right? It's my life. It's my appraisement of this movie. It's my table. It's my car. So the word my or your or possessives, but they don't always imply legal ownership. So I think that, again, this is why I tried to distinguish economic versus legal concepts. When you say you sell your labor from an economic point of view, that's just a way of describing what happened in the transaction, which was that someone transferred their money to you to induce you to perform an action they wanted you to perform. And you perform the action to trigger the conditional transfer of title to you of the money. So really a labor contract or a labor sale is really a one-way title transfer. There's only one thing that's being transferred, and that is the title to the money.
Which is fine.
It's not a two-way title transfer. Yeah,
like,
it's fine.
Yeah,
it's
that's
fine.
a common misconception is that you have to have a two-way, like there has to be consideration or something, I think is the language. Like you have to have property going in both ways for it to be a valid contract. I think that's superfluous, right?
That's a good point. I'm actually not sure if consideration has to be an owned resource or if consideration could be a service. I don't know the answer to that, but that is rooted in the classical idea that contract has to be an exchange legally, right?
But a gift is a contract.
Valid.
Yeah.
I mean, according to the civil law, you can have a gift. It's called a donation, right? Or it's a gift. And I think that's just as valid as the way the common law gets out of that is they say, well, if you promise to give someone a resource and they rely on it, then you can't go back because that would be harming them. So they have this convoluted way of trying to get out of their hampered rules in the first place. But yeah, I think the solution is, look, there's two types of contracts. You can give someone something as a gift. You can give it based upon a condition. And that condition can either be the reception of title to another thing, or it can be you're performing a service. They're all fine legally. From a libertarian point of view, they're all fine legally.
Agreed. Jim Jesus donated $2. He says, having Kinsella on your show is a limited liability. I don't know what that means, but let's go with it. Liberty After Dark. It doesn't have to be theft, though. If the terms of the contract are violated, the associated penalties would be dealt anyways.
I think I know what he's getting at there.
Okay.
So technically, I would say it's impossible to violate the terms of a contract. It's just simply that if you perform an action that triggers some title transfer in the contract, that's what happens. And that could be if you don't perform the actions that we wanted you to perform, then you have to pay us some kind of money. And that's you can call it a penalty. And that's what the problem with calling it a penalty is if the courts call it a penalty, they won't enforce it because they say that's the job of the criminal system is to enforce penalties. That's the problem with liquidated damages clauses. If they're too high, the courts won't enforce them because they say it's a penalty, and that's not the job of the civil courts or of private parties and contracts. That's the job of the criminal system. So you don't want it to be characterized as punitive or as a penalty. But from our point of view, as businessmen or whatever, yeah, we can say, yeah, you're going to have a penalty if you don't do this. So that's why you're going to do it. Right.
Debo asks, let's see. Jim Jesus says, promise to stop watching porn. Well, this video will get banned from Pornhub now. Out of all the platforms we publish to, Pornhub has taken down more videos than any other, for reasons we can get into at another time. Debo says, is the law a contract?
That's an interesting question.
I mean, what is it if not a unilateral by fiat contract, right? Like, which is to say invalid, right?
So some people they call them contractarians. I'm forgetting the name. I can't think of any name. Raz maybe. Forget. There's it's a famous philosophy book called Morals by Agreement. And even like in Hoppe's theory, he talks about people agreeing to respect each other's rights. Now, I think that when he used the word agreeing, he's not using it to mean contract. I think he's using it to mean the willingness of people to respect each other's rights. Like we're both recognizing that each of us has the right to control our bodies and any other resources that we get by valid means, right? So I think that property is the basis of contract, not the other way around. So I don't think you build law on contract. And by law, I mean the basic law, the basic libertarian non-aggression principle and related rights. But I do think that as a matter of fact, in any private society, the bulk of the law what we think of now as law would be private law. And the bulk of that would be that stuff developed by convention and custom and by contracts. A lot of it would be contracts, insurance company contracts, right? Or covenants. I think actually a large part of the kind of background public/private law would be dominated by the terms and clauses that insurance companies would insist upon to cover people. And people would want insurance coverage to be accepted into polite society and to do deals with people and to live in a certain community, all those kinds of things. So these sort of little, almost mini treaties between insurance companies and protection agencies and between their customers would, over time, would fill in the borders of what we now think of as a private law. So they wouldn't really be legislated, but they would be the result of written agreements. And so I see that process as probably what could and would happen.
You said something just now that makes me want to go through my conception of what rights are, because it seems like rights are a contract. So let me just lay it out. Give me a couple minutes to rant through it. So I say that rights are a mutual reciprocal understanding between sentient beings. And every word of that sort of means something, right? So a mutual reciprocal understanding means that rights are an agreement between people that has to be reciprocated. So if property being one of the rights, let's say, if we have to agree to this thing called property and reciprocate it amongst each other for it to even be operative in the world, like without us respecting each other's rights, property rights, then property doesn't really exist. It sort of ceases to exist because it's just a conceptualization that we hold in our minds about how we interact and resolve conflicts and prevent conflicts to scarce resources. So it seems like an agreement, some form of contract, sort of precedes property existing. Like for us to interact around a system of property rules and to agree on first use as a premise for establishing highest claim of ownership, well, that's sort of an agreement, right?
Right. That's why I said, and I think the name of the guy is, I think, David Gauthier. I think that's who wrote Morals by Agreement. And there's other contractarian thinkers too. That's why I said I think there's a difference between the word agreement and the word contract. So again, you and I talked about what's the right way to define contract, but it basically comes down to the owner of a resource consenting to its alienation from him, right? Giving the use over to someone else, right? Either permanent or temporary or whatever. And typically it's permanent. It could be conditional, but it's permanent once it happens. Like you give this to someone else, which is, by the way, one reason I kind of disagree with some of my fellow IP haters who they'll jump on the idea of like the seller of a book retaining some rights in the book, because once you sell the book, you have to sell all of the book. Like that's not really exactly right. And that's not really the problem of contract, because copyright doesn't come from contract in the first place. So they're almost trying to say you couldn't have co-ownership rights and things, but you can, right? You can have co-ownership, like a husband and wife co-own their house together. Avis and you, in a sense, co-own the car for that day. You have the right to use it. They have the right to get it back. And
I own my house, but I did not purchase the rights to build a 100-foot tall fence around it because of my HOA restrictions. Yeah. Yeah.
So your neighbors own a partial limited control contractual right. Yeah. So, but that's a division of rights, and that's a co-ownership situation. And so theoretically, if I sell you a book, I could, as the publisher or the author of the book, I could keep the right to copy, which just means that as between you and me, you're the buyer of the book. We have a contract where if you copy the book, you have to pay me some kind of money. Now, I don't think those contracts are practical. I don't think anyone would ever agree to them. And
really hard to enforce that.
It'd be impossible to enforce. And we're talking a $5-10 book. Who's going to do that? And then not only that, it wouldn't bind third parties. So the ideas can still get out there, and then the copyright doesn't form. So that whole argument is flawed. But I think that the nature of rights. So rights, number one, if you think of Crusoe alone on his island, he has no rights because there's no other people. There's no one that can violate his rights. He still needs to use resources to survive, but he has no rights. When there's other people around, we might say he has rights. So we know that rights have to have a social aspect, like their rights against other people. And they also have something to do with violence, physical conflict or violence, because there's no way to have a conflict unless we have a clash. And the only way to have a clash is over physical things in the world that we might want to use at the same time, right? So rights have to, the definition or the concept of rights has to tie into both of those things. So your earlier definition is too broad because you just said it's some mutual understanding or something. But I mean, that would maybe apply to language too or something. So it would have to be narrowed down a little bit. That's a difficult issue. But I do think that the way I think about it is Ayn Rand was right that all rights are individual rights, right? And all individual rights are human rights because only humans have rights. And as Rothbard said, all human rights are property rights because that's what rights are. They're rights to the exclusive, basically the right to exclude someone from the use of a resource. Further than that, it would take us far afield, but how they arise and how we justify them, I'm not strongly opposed to having a contractarian base, but I think they're talking more about the fact of agreement among people and respect among people for each other's status as rights bearers. But contracts that we've been talking about here is more of a subset of property rights because it's how you use something that you have a property right to.
Liberty After Dark says, this is like a square can be a rectangle, but a rectangle isn't a square. A contract is an agreement, but an agreement isn't always a contract. I mean, you can be in agreement with people on, what song is Metallica's best song. That doesn't mean any property is being used or transferred, right?
And this is an important point. I forgot. I wanted to mention this earlier. Earlier, I was trying to quibble over oral versus verbal and all that because there are differences, right? And even the definition you read, which seemed fairly precise on Wikipedia, said that a contract is like a legally binding agreement. So it's a subset of agreements. It's a type of agreement. So not all agreements are contracts. That is true. And just the examples you gave wouldn't be a contractual agreement. It wouldn't be a contract at all. There would just be an agreement. We both agree that something is true. We agree that something is the case.
Yep.
Means we have the same opinion.
Last call for questions in the comments. Now, the last thing I have on my notes that I wanted to go over with you, and we've already kind of talked about some of these, but what are contracts not, and common misconceptions of contracts? We've already kind of gone through a couple misconceptions, but do you have any others that kind of pop out? Especially, I know you have these conversations with libertarians all the time. What are maybe the most common misconceptions about libertarian contracts that you can think of?
I think other than what we talked about, I think that's about it. I mean, the idea that they have to be written, they don't have to be written. I think, again, the idea that we talked about implicit contracts are inherently flawed and give rise to the social contract idea. And by the way, I hate the social contract idea as much as you do. Although there's a slight grain of truth to it in the sense that civilized people do tend to agree on a certain background set of norms about our rights, but not things you have to do, not positive obligations. I think that may be the difference. But no, I can't think of any other major. Well, I think the major misconception is the same one the lawyers make and the legal profession makes, which is thinking of contracts as a binding promise. Just stop thinking of it as a binding promise, but think of it as just the exercise of an owner over his resource about who he wants to transfer it to. That's what they are.
I know Block, speaks in favor of implicit contracts. You walk. I think the example he uses is you go into a restaurant and you order food and they serve the food and you eat the food and then on the way out you pay for the food. And at no point in that story was a contract signed where you agreed. I mean, maybe look if you look at the menu and see the price next to the food item, I guess that could be considered an acknowledgement or an agreement explicitly. Right. But let's say you just walk in and don't look at a menu and, just say, hey, I would like some steak, and they bring you a steak, and price and compensation was never mentioned. What are your thoughts on implicit contracts from that angle? I think it isn't, and I don't think it's that difficult to actually just make the contracts explicit. And so I don't really see it as I don't really see holding the position that implicit contracts are just not a thing. It's dangerous to make assumptions in contracts, and it makes an ass out of you and me, and it's not necessary. And it would be real easy just to have people walking in your restaurant. Hey, make sure you look at the menu, because if you order food, we're going to expect you to pay for it. That's not a big deal, right?
I think that you're probably a little bit more worried of this than you need to be, because we have a statist legal system, okay, which I understand. But in a private legal system, I think the concern would be far less. There's far less danger that someone's going to come up with a crazy implicit term. Just like I said earlier, I don't think even if you have an explicit term in the fine print that you sell your baby, or you sell your salary, you transfer your salary for the rest of your life, just because you bought this one software package from Microsoft or whatever, that wouldn't be binding. And by the same token, anyone who asked you to pay $1 million for the steak when you didn't agree to it, they're just not going to be successful. And if they ever are, then customs would change quickly so to prevent that problem from happening. So these problems are basically self-correcting. I think there's like a good negative feedback effect that happens, and customs, when they're sufficient, people rely upon them, and when they turn out to give unpredictable results or very costly results, then people will take the extra costs and steps necessary to figure it out. But the point is, you think it's not that hard to do an explicit contract, but sometimes people don't do it. So if I walk into the restaurant and there's no menu, and I just say, let me have a steak, and they serve me a steak, and then the guy presents me for a $1,000 check, and I refuse to pay it, now there's a lawsuit. So then we have a property dispute. The question is, who owns the $1,000 in my account? Is it me, or is it the restaurant? And the legal tribunal, whatever system you choose, has to come up with an answer. So the answer can't be, well, you should have had a contract.
Why not? Why can't that be the answer?
The answer is going to be someone.
Like when you order the food, they could just, give you a box to check or something. Yeah, that's what you want. Oh, there's the price.
They could, but what if they didn't? I mean, what if you have a situation where there's no menu?
Buyer beware.
You walk in.
Seller beware, right? Okay. Same thing, right?
Well, I don't know, but that's the point. Which one is it? So those are the default. So Cavan and Tor, which was
humans beware.
Well, they both have to beware, because they're both taking the chance that they could lose in a lawsuit because they didn't take the time to work it out. Mm-hmm. So I agree with you, but you can't just say buyer beware, because maybe it's seller beware. I mean, maybe the seller should insist on having their customer, So I remember when I went to Hungary one time, right after the wall fell on a trip, and I went to a restaurant with my buddy. We walked in and we couldn't even speak the language, and the lady said, "You want food?" We said, "Yeah." So she brought us food. Like, that's what we ordered, food, because I couldn't explain it. And it's like, and we'll pay price. You bring us food and we pay price. It worked out.
Where do you draw the line, though, with when you were talking about, like, you agree to use a piece of software and suddenly you lose custody of your child, right? Where's the line, though, in other things in that agreement that you definitely take positive action to definitely communicate your assent and agreement and consent to that contract, and all parts of it, right? Like, how do you? It seems very subjective what you just introduced there, right?
It can be difficult. This is partly what lawyers do and partly what courts do. But it goes back to something you said earlier, which something I've emphasized too, which is true. A written contract should be looked at only as evidence of the actual underlying contractual agreement, right? So, and again, if you don't think of contracts as a piece of paper that people wrote things down on, like you understand that contracts don't have to be written, then even if they are written, it doesn't mean that that's the actual meeting of the minds, the deal. Like it's maybe presumptive evidence, and maybe it's 99% of the time accurate. But in some cases, it's going to be so egregious that you realize that the other party really didn't intend for this to happen. So then it becomes a factual question. And that's the job of courts, is to do fact finding, like to ask questions of the sides. And,
so the contract,
really think that the,
go ahead.
Yeah. No, the contract is just evidence, very powerful evidence. It's sort of like a confession. If someone signs a confession they committed a murder, does that mean that they really committed the murder? Not always.
I like the distinction between intent and consent and what's actually written in the contract, because it is important. That's a good common misconception. Like, it's just evidence of some level of agreement, right? But I mean, that's the whole point. Like if you put your signature on a contract that says you transfer custody of a kid, like, I guess you would have to also, as part of that contract, agree to an arbiter. Like, you would both have to consent to this arbiter making that subjective interpretation of what is an unreasonable term of the contract. Like, oh, he was just trying to use Microsoft Word, man. He wasn't trying to give you his kid. That's dumb. Like, why did you even put it in there? Like, you would have to agree to that arbitration, right?
Yeah, exactly. And if that was a custom, that you could assume that's going to happen, but if not, you'd have an arbitration clause. And then I think Microsoft would know that if we go to arbitration, we're hosed, because the jurors or whatever, that they're going to say, come on. The guy didn't mean to give you his kid. Or, I mean, look, my wife and I were married, and we had powers of attorney for each other. Statutory Texas powers of attorney, and we just sold some property, and she was out of town, and the closing company insisted that we get another power of attorney for this specific transaction, even though legally the other one's fine, because when certain things are high stakes, people don't take chances, and they amp up the legal coverage when they think they need to. This is a natural negative feedback from bad outcomes that have happened in the past, and people learn from these things. And the law progresses. That's one reason I think. I mean, I don't say I love lawyers any more than the average person who makes fun of lawyers, but I tend to think that in a private society, we might have more lawyers, not drug defense lawyers and prosecutors and people like that, and antitrust lawyers and IP lawyers. They would go away. But private law lawyers, there might be more of them, because people would be richer, and they would have bigger deals, and they would have more spare money set aside to afford to hire a lawyer to just paper over every tiny, fine detail of this contract. So maybe there'd be more lawyers used because we could afford them, and the deals would be more and more complex and more in need of legal fine tuning. So
I absolutely agree. I absolutely agree there'd be more lawyers, and I would hope there would be more lawyers, because we need to drive the price down. Right now, they have a government-backed monopoly on the law license, and there's a restricted supply of lawyers, right? So that's one of the reasons why they're so damn expensive, and it's so hard to get good representation, is because the same thing with doctors. There's a big restriction in that supply as well. All right, sir, this has been an amazing conversation. Thanks for hanging out and going through Is there anything that we missed with contracts? I think we pretty much covered it well enough for this episode.
We did a pretty good job.
Hell yeah, we did. Hell yeah. So where can people find your work? Where would you like to send people to find more of Kinsella? StephanKinsella.com. And if you go to /LLW, that's the notes for my forthcoming Libertarian book. And I've got a chapter online already on my contract theory, which is based upon Rothbard and Evers. So I've got a couple of good articles on contract theory that go into the background of all this stuff that we talked about today. All right. Well, thanks again, sir, for coming on, and hope to see you soon. Maybe we'll get you an Anarchast soon, and we'll go through some other cool topic. But everybody, thanks for watching. Thanks for the super chats. Peaceful, easy feeling. Jim Jesus, you guys are amazing. Thank you so much. And we will see you next time.
Peace out.